Mr. Adams.
May it please the court. Counsel, in this Stenzel case, this court set forth that there were two ways to obtain a civil commitment under Chapter 229A. One being a recent overt act, the other being that the person was presently confined. This case is about what presently confined means. Does it include a person who was released from prison after completing their sentence and was in the community, in a residential facility in the community where he could come and go at will for 7 months prior to the state filing a petition to have him civilly committed? This court is extremely aware that their task today is to give effect to the intent of the legislature. And if you look at what the legislature has said, look at the plain, unambiguous language used by the legislature, you can clearly see that the legislature intended that sexually violent predators under the presently confined scenario have to come from a situation of confinement, or they are not presently confined. And I guess it just makes sense if you, and there's four things essentially to look at. First thing is 229A.1, the intent of the legislature, legislative findings. They talk about extremely dangerous, sexually violent, predator. I don't want to say that the legislature had disdain for these folks, but they were clearly communicating a concern that these people are extremely dangerous beyond the danger posed by a normal sex offender. These folks are worse. They created a system where these folks are placed in total confinement in a secure facility if they are found to be a sexually violent predator. It makes sense as a preliminary matter that if a person is so dangerous that they need to be placed in total confinement, we're not talking about the people that are in a residential facility that go to a job every day, that go to a grocery store every day, that go across the street and have ice cream at the leisure. If they are so dangerous that they need to be put in total confinement, we would expect to see that behavior as they are free in the community, i.e. a recent overt act. So in 229A.1, the legislature sets the framework. This is the kind of people we're talking about. Next, look at 229A.3, which is the process that the legislature created for how this whole commitment process begins. And again, if you look at the plain and unambiguous language of what the legislature said, their intent is evident. It talks about, in subparagraph 1, that the agency with jurisdiction shall give written notice to the Attorney General and the multidisciplinary team established in subsection 4 no later than 90 days prior to any of the following. Paragraph A, the anticipated discharge of a person who has been convicted of a sexually violent offense from total confinement. It goes on to say, except that in a case of a person who is returned to prison for no more than 90 days as a result of revocation of parole, written notice shall be given as soon as practicable following the person's readmission to prison. Again, nowhere do they talk about residential facilities, nowhere do they talk about special sentences under 903B as Mr. Wygle was serving. Of note, and even though we're not talking about it in this particular case, but when we're talking about folks facing commitment who have been found not competent to stand trial and who are found not guilty by reason of insanity, that would be paragraph B and C of 329A.3.
Make of the fact that we're interpreting 229A.4, which uses the phrase presently confined, and then you just quoted from 229A3, the notice provision, which uses total confinement. Is there some distinction that the legislature was trying to draw between confinement and total confinement?
No, Your Honor, I don't believe so.
Why not?
I believe the two have to be read in the same vein, in the same light. It would make no sense for them to distinguish in Section 3, make a distinction, make a definition, and then have a different definition in Section 4. Again, I think it goes back to the danger that the legislature sought to prevent, and that is these terribly dangerous folks. They're in total confinement now. We want to keep them in total confinement because to let them out, they're likely to commit a sexually dangerous crime. So I think paragraph 3 talks about the notice, that this is how this whole thing gets rolling. I don't think they needed to say it a second time in paragraph 4. I think paragraph 3 sets the terms, and paragraph 4 follows logically behind that. Going back to the not competent to stand trial and not guilty by reason of insanity, Chapter 812 requires, if a person is found not competent to stand trial, Code Chapter 812 requires that they be placed in total confinement and that their competency is attempted to be restored. For a person that is found not guilty by reason of insanity, Rule of Criminal Procedure 2.22, parentheses 8, provides that those persons will be totally confined. So in every place where the legislature talks about civil commitment under 221A or 229A that does not include a recent overt act, they talk about moving a person from a place of total confinement, either by express terms or by what they knew at the time to be true, to another situation of total confinement, that being the secure facility. The legislature clearly knew the law when they passed 229A. They knew about 812, they knew about the rules of criminal procedure, and they passed the statute and put the words in it that they put in.
Let's take a look at 229A2.1, which is agency with jurisdiction. It's a definitional provision, and it ties in with later provisions. But agency with jurisdiction is defined as includes but not limited to Department of Corrections. But then it goes on to say Department of Human Services, the Judicial Department, District Correctional Services, and the Board of Parole. The state suggests in its brief that, well, if the Board of Parole is an agency with jurisdiction, then that tends to undercut your total confinement argument. A Department of Human Services, I mean, the agency with jurisdiction is fairly broadly defined. So what's your response to the state's position?
I agree with their assertion that agency with jurisdiction is broad. I disagree that it carries the day in this case. The agency with jurisdiction, most likely when these cases are filed, are the prison, the Iowa Department of Corrections. It can be the Henry County Sheriff, as it was in the Willis case. A person who has been placed in transitional release after having been committed and moved up into transitional release, or granted release with supervision, they are supervised by either the parole department or correctional services. Those people, by statute, have not been discharged and are still civilly committed under 229A. So I think that's what the legislature was after, that if any one of these people that have custody or responsibility for a sexually violent predator or a person who becomes a sexually violent predator, they should have the ability to bring an action before the court and have it heard. If you look at Chapter 903B. And again, this was enacted after 229A had been on the books. The legislature did not alter 229A after the 903B special sentence was put on the books. 903B special sentence, by its terms, takes place or begins after the completion of any sentence given in connection with the original criminal case. To begin a special sentence, the person begins that sentence as if on parole or work release. If they violate the terms of their release, they are returned to prison. I believe the first offense is 2 years, not to exceed 2 years, and I believe it can escalate to a period of 5 years for subsequent events. If a person is confined in the on a special sentence as totally confined, they would not be returned to a position of total confinement for violating the terms of their release. Finally, I've cited the court to the West case. It's an unpublished case of the Court of Appeals. They sought, as this court has often done, looking at the dictionary for the meaning of common and ordinary terms. And when I've cited it in my brief, because I'm getting close to my time here, they looked at the words confine, and confine, as indicated in their opinion, according to Webster's Webster's Third New International Dictionary of 2002, means to imprison. They also go on and say, for legal purposes, Black's Law Dictionary says the act of imprisoning or restraining someone, the state of being imprisoned or restrained. Then they talk about total, whole, not divided, complete. Putting the terms together, total confinement means full imprisonment. Now, the Court of Appeals decision obviously is not precedent for this court, but the rationale makes sense. It makes sense that total confinement is what the legislature was after in this case. And the way the Court of Appeals has broken it down with resort to the common, ordinary meaning of simple words, the words that were used, makes sense. The court also went on to consider that given the legislative intent to protect the community by keeping SVPs in secure facilities, it makes sense that such a petition should be filed before a potential SVP is released into society, even if the anticipated release is subject to parole, probation, or any other kind of supervision. The plain and unambiguous language used, coupled with an understanding of the ordinary words and given their ordinary meanings, leads to the conclusion that the legislature was not going to take a person who is in less than total confinement, and because they are so dangerous, move them into a state of total confinement. If that person in less than total confinement is so dangerous that they have to be totally confined, you would know that, we would know that, because they would have committed a recent overt act. And as the court in Gonzalez said, recent overt act is required by due process. When a person has been out of the community and incarcerated, that deprives the state of finding or pointing to a recent overt act. In this case, Mr. Wygle was free in the community for 7 months. He rode a commercial bus from prison to the residential facility. He was free in the community for 7 months. He was not presently confined, as the legislature intended. For that reason, Mr. Wygle is asking this court to remand this case to the district court for dismissal of the petition.
Thank you as well, Mr. Adams. Mr. Bowler.
Good afternoon, and may it please the court. This case is really nothing more than straightforward statutory construction. What does the term presently confined, as used in Chapter 229A, mean? This court said in Schaefer and in Willis that this is a flexible term. It's not hyper-technical. But what the respondent is asking for today is for a very narrow, inflexible definition. He wants this court to say that presently confined means total confinement in prison or in jail. And what the respondent's asking this court to do is read words into the statute that simply aren't there. Iowa does not have a total confinement statute. And I want to say that again because this one sentence disposes of the case. Iowa does not have a total confinement statute. There are some of those out there. If we look at Washington's statute, they use the words total confinement 22 times. Iowa's statute is not similar. The phrase total confinement appears only once, and to respond to Justice Appel's question earlier, it doesn't appear in the elements section. It appears in the section that talks about notice. Who has to tell the Attorney General that they have someone who might be an SVP? And we know that that provision of the statute is not a substantive limitation on the state's power. We know that because this court already said that in Huss. This court described that provision of 229A as a heads-up provision, and I think that's accurate. It's a notice provision that does not talk in terms of substantive limits on the state's ability to confine someone as a sexually violent predator. The only
Give me an example. What's the basis of filing this 7 months after the person's in a residential facility? When, to me, the statute is, and I agree with what you're saying, it may not be a total confinement statute, as we call it, but the language to me is fairly clear when it talks about being confined. He is out in the community. He's at a residential facility. Why 7 months later is it the Department of Corrections or is it the Department of Correctional Services? Who is the person who's doing this and why at this point?
There are a couple pieces in your question, and I want to make sure I address them. Bring me back if I don't, Your Honor. The first is that I don't agree with the characterization offered by Mr. Adams that the respondent in this case was out free in the community. He was not. He was placed at a residential facility under the corrections continuum. That is a level 3 quasi-incarceration sanction. The record doesn't give us a lot of details about what exactly the limitations on the respondent's movement were, but often these are severe restraints on mobility and on the liberty of the individual. In fact,
what about just a quick little fact that I think was in the briefs that talked about, they put him on a bus, okay, and then put him on a bus. He travels by himself. He's not escorted in any way to Cedar Rapids, then to Marshalltown, then I guess ultimately ends up at the RF in Ames. But that doesn't sound like there's a lot of restrictions. Sure, there's going to be restrictions at the RF about his mobility and all those things that you're talking about, but that doesn't. I guess I just want you to respond to that as well as part of the question.
Sure. I think it's not a surprise that for resource reasons, DOC didn't have its own bus that took this person to the RF to be placed there. I think the statute really talks about two different states people might be in. One is total freedom out in the community without supervision, and one is restrictions that are generally analogous to confinement. So if you're going to try and plot this case, which is it closer to, we're much closer to confinement. This person is required to stay at the residential facility. We don't know the exact restrictions that are on him, but we know that in general, 903B special parolees are required to adhere to at least level 3 corrections continuum procedures. And in fact, the code would make it a felony escape for the respondent to walk out of the residential facility without the permission of the director of the Department of Corrections.
Let me try and ask you about this. I mean, it does seem to me we have to interpret the word confinement consistently in the statute. If you look at 229A2, the definition of a sexually violent predator is someone who's essentially dangerous, if not confined in a secure facility. So it seems to me that doesn't that suggest that the idea is he has to go from one confinement to another? I mean, in the whole point of the state is he's not confined in a secure facility at the time he was in the halfway house. That's why we need to get him in Cherokee.
Let me parse out a little bit there. I think he is confined in the residential facility. I don't think it is total confinement, as some other state courts have interpreted their SVP provisions. If we look at the most analogous state court decisions, that takes us to Kansas. The Kansas statute was really the first and perhaps the best known of the SVP laws. It was upheld in Kansas v. Hendricks. It was essentially the model nationwide. Kansas's statute, unlike Washington's, is pretty close to ours. The driving term there is presently confined, just like it's used in our Chapter 229A. And in Kansas, their Supreme Court has said that a person on post-release supervision is still subject to that present confinement requirement.
So what does that mean to you, post-release supervision? Does that mean if you're subject to 903B restrictions, that's supervision? I mean, query?
I took a look at the Kansas statute to try and figure out what we could best analogize their post-release supervision to. In some circumstances, I do think it's very close to 903B. They have a corrections continuum that is generally similar to ours.
Here's my problem with it then, and I'm interested in your response, obviously. For some offenders, 903B, it can be a lifetime of supervision, if you will. And so, under your interpretation, does that mean that any time during the course of a person's life, the state can kind of decide, well, there was a sexually violent act for which he was convicted and discharged. He's under 903B, and then 25 years later come in and seek civil commitment without a recent overt act?
That is the state's position, but let me suggest to you the court does not need to go that far for the state to win this case or to win the Tripp non-oral companion case. Even if this court were to hold that placement in a residential facility under the restrictions of level 3 supervision on the corrections continuum, or incarceration like in Tripp, that's enough to meet the requirements of this petition. I do know that we have not filed an SVP petition against someone who's essentially just on paper without any of these kinds of restrictions. We've chosen people who do meet an analogous definition to confinement. Here, this is a person placed in the residential facility with significant restrictions on mobility and liberty, and in fact, it's a felony if they walk out the door without the permission.
Can presently confined mean just part of the day? If he has to spend his nights there, is that enough?
It is, Your Honor. I think that's what the Kansas court essentially came to the conclusion of. If post-release supervision is generally analogous to 903B, perhaps it's a little bit different. We see corrections placements that are similar to our residential treatment facilities. Sort of in the common parlance, they're called halfway houses, or maybe there's somewhere like Fort Des Moines here in town that's more like a work camp. But either way, these are restrictions on the mobility and liberty of the person that meet the requirement of presently confined.
I mean, you know, from a policy standpoint, normally, as I understand the philosophy of corrections, if the person is doing well and they're getting greater and greater freedom, you don't yank that freedom away absent their having done something to justify doing that. I mean, and isn't that sort of the philosophy of the statute, that before they're discharged from prison or jail, that the state is supposed to go forward and get this SVP determination?
In an ideal world, I think that's right. There are unfortunate cases where DOC is not able to give notification in time. For example, there have been a number of cases where this court has changed the calculation of good time or earned time credits. There are emergencies where someone walks out the door where an SVP petition would have been filed. But I want to step back a little bit and address the policy issues that are in your question. There are two paths under 229A. The presently confined path basically makes the argument that this person has been locked up and has not had real opportunities to reoffend because they've been incarcerated. The alternative is the recent overt act, which says this person is out free in the community, there are no restrictions, so they have had many opportunities to reoffend. If we're gonna plot this case closer to one end of the continuum, it is much more like someone who is presently confined. This is a person still under the jurisdiction of the Director of the Department of Corrections by way of 903B and under the Board of Parole as part of their special parolee conditions. This is a person still subject to monitoring and supervision by the state. They're required to go to a specific place. It's a felony if they leave, if they don't show up, if they're talking to people they're not supposed to,
No,
the
but they
state
have-
will be involved.
Yeah, sure, but there's lots of opportunity, lots of more opportunity than in incarceration in prison. I mean, our cases, as you know, emphasize the fact that the fact that you can use the original offense as the reason overt act is, well, you're locked up, and, you know, the cases say basically that you don't really have an opportunity to reoffend when in prison. And therefore, we deem backwards to the original offense, if you will. Admittedly, there's restrictions involved in the residential facility here, but yet a fair amount of the record actually is pretty sparse on it, but a fair amount of exposure to the community, surely, right?
I wouldn't agree with that. As your question suggests, we do have a somewhat limited record here, but it's important to remember when
Where does that fall, I wonder? I mean, the record is, shall we generously say, sparse on the question. So where do we go from there? I mean, whose burden is it to show that it's a secure facility or not a secure facility?
Well, we're on interlocutory review of the respondent's motion to dismiss, so it's the light most favorable to the state, the non-moving party in this case. Any information we do have in the record has to be interpreted in the light most favorable to the state. I want to address something else that was in your question about this opportunity to reoffend and whether that was present here. We need to remember that for this offender in particular, and a great number of the offenders at CUSO, the treatment facility, these are generally pedophiles or force rapists. They would not have had an opportunity to reoffend under these circumstances. We know that a standard condition of parole for a 903B would not to be having unsupervised contact with children. Was the respondent in this case on a bus that took him from a DOC facility to another DOC facility? Sure, that fact is in the record. There's no reason to think that this respondent had the opportunity to offend against children like someone who was released from confinement would. There's no evidence this is someone walking down the street with access to children. So I think that we are still talking in a situation that is most analogous to present confinement. There's a severe limitation on his opportunity to reoffend due to his placement in a DOC facility. I want to talk just a moment about a point the court raised earlier about the agency with jurisdiction and the broad terms there. We have to read all of Chapter 229A together. Total confinement appears just once in this notice provision, and notably, no definition is given for total confinement, even though we see in these states that do have a total confinement statute, it is given a definition. What we see is that the references that are included go much broader than just jail or prison. If we were talking about only jail or prison, the statute would say that agencies with jurisdiction include the sheriff's office and include the Department of Corrections. But that is not what the statute says. It includes Judicial District Correctional Services, it includes the Board of Parole, it includes the Department of Human Services, all of which operate facilities that fall short of a level of confinement that you might find in a maximum security prison. Justice Mansfield, you asked earlier about the philosophy of basically moving offenders to least restrictive placements. I think adopting the respondent's argument in this case undermines that rationale, because if this court's going to hold that someone basically has to be held in the most restrictive environment possible if the state's going to file an SVP petition, that disincentivizes the Department of Corrections for placing someone on perhaps a work release where they wouldn't have access to children if they're a pedophile. There might be legitimate reasons the Department of Corrections wants to see if that offender is meeting the rehabilitative needs they are looking for. But if walking that person into a work placement means the state can never file an SVP petition, the Department of Corrections will choose not to do that and will instead choose a more restrictive alternative approach. As I said at the opening of my argument, Iowa's statute is not a total confinement statute. Less than total confinement is sufficient to establish someone is presently confined. I would ask this court to affirm the denial of the motion to dismiss.
Thank you, Mr. Bowler. Mr. Adams?
May it please the court. If this court rules that Mr. Wygle should win, that will give the DOC a disincentive to put people on work release because they won't be able to file an SVP petition. I submit, Your Honors, a person who meets the criteria of an SVP, meaning that he is so dangerous that he must be confined in a secure facility, is not going to be put on work release by anybody in DOC.
Yeah, let me ask you, both your arguments are very helpful in trying to work through this statute. I have another question for you. All right. So you say 229A41 is not applicable here because your client was no longer confined within the meaning of that statute, right?
Yes, sir.
And then what if he commits an overt act while he's at the halfway house? Say, while he's on release from the halfway house, he commits an overt act. How could he be pursued under Alternative 2 because he's convicted of a sexually violent offense, but he hasn't been discharged after the completion of the sentence imposed for the offense?
He's been discharged from the original criminal sentence at that time and is on a special sentence. So you have to read the entire code in this particular case, 229A and 903B together and see, try to find the commonality in both the statutes.
But what if he's on parole but not the 903B special sentence?
He is in the community and has sexually violent offense, then yes, that is a recent overt act. He's been discharged from the confinement portion.
It doesn't say that. It says discharge from completion of the sentence. See, I don't think the legislature intended to create a loophole where you couldn't pursue an SVP action against somebody who committed an overt act after they had been released from prison, but before they had discharged their sentence.
Right, and given the court's cases about a person being, I guess free, you know, what constitutes being presently confined, and so forth, I think that the person that is not in prison, as the Court of Appeals views, a person that is not in prison that commits a sexually violent offense, that person has committed a recent overt act. And a petition could be filed, and that person is properly subject to commit for that. You talked about a person that is presently confined some of the day while he lives at night at the residential correctional facility. Imagine that that person is let out in the morning to be at work at 8 o'clock. He gets off work at 4:30 and has to be back to the correctional facility at 5. He is unsupervised the whole day to and from work, and while he is at work, counsel wants us to speculate whether victims are available to him. Certainly victims are available to him because he's free that he's not in prison. And the cases that talk about in prison say that's why the person may be a substitute for recent overt act because victims are not available when the person is in prison. There are, however, once the person is released. Counsel talked about there being a felon who would walk away from the residential facility. And I want to emphasize if these people that live in such a situation every person clearly not what the legislature had in mind. The legislature had in mind to give these folks treatment, but at the same time provide security to society. And the legislature found the only way to do that was to keep them in secure, confined, what is supposed to word in prison situation. Again, I would ask this court to please
Mr. Adams, thank you as well. The case of in re the detention of Nicholas Wygle is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.